Hello there. I hope you're doing great. So once again we meet. My name is Mr. Mtiaba Conrad, and I'll be taking you through civil procedure. This time we're going to be looking through the past papers so that you're able to appreciate and learn how to answer some of these exam questions. So I'll be taking you through civil procedure 2, and specifically we are going to look at a past paper exam, and we are going to look at the U.C.U, that is Uganda Christian University Civil Procedure 2, past paper of 3rd May 2021, which was last year. So please try and find that past paper. We are going to be looking at question number 1, which is the compulsory or the so-called problem question or the legal question. We are going to look at it. So basically in this video, you're going to learn how do you formulate issues when you're doing an exam of civil procedure. And you're also going to look at some of the techniques of how certain questions can be quickly answered. So I hope you have that past paper with you. That is the U.C.U, that is Uganda Christian University Civil Procedure 2, past paper of 3rd May 2021. So find it so that you're able to follow throughout this discussion. But for those that are not able to find this past paper, maybe you're from some other country or anywhere, just for purposes of following this discussion, I'll just summarize the brief facts of that past paper, which are as follows. So the brief facts are that Mr. Mitima Jakaluba was sued by Mr. Nananana for trespass to land, which Mitima inherited from his grandmother and on which he currently resides. Out of the 6 witnesses produced by Mr. Mitima, only 3 were allowed by the judge, relying on bad weather as the ground for the rejection of the other 3. So Uncle bent down's evidence of proof of ownership of a Chibanja interest, together with a 1982 purchase agreement of the Chibanja, were also rejected by the judge. The lawyer who was representing Mr. Mitima Jakaluba was denied by the judge to cross-examine Mr. Mananana because he was the prince of Toro Kingdom. The case ended in favor of the plaintiff on 30th of April 2021, and damages of 50 million shillings were awarded, and an order to vacate the suit land and costs of the suit were also granted. Of course, the task here that we are required is to advise Mr. Mitima Jakaluba. So basically, those are the brief facts of this problem question. But again, I encourage you to go and find that past paper and you read through the full facts. But basically, those are the brief facts. So we are advised, our duty is to advise Mr. Mitima Jakaluba. And when you look at part A of that question, which I presume you are now going through, the best issue, okay? But before we even go to part A, it's important to always know that order of FILAC, okay? So you summarize the facts. Make sure if you're summarizing your facts, they're as brief as possible. When you're summarizing facts, you capture the names, capture the dates, capture the time, and capture the key issues. So when we are talking about brief facts, these facts should really be brief, okay, very brief. Then, of course, after that, you have to raise the issues that you would have gathered from the brief facts. So you raise the issues, and of course, after that, you have to look at the law applicable. You state the law. And of course, for purposes of this discussion, we're going to be looking at a number of laws, including the Constitution of the Republic of Uganda of 1995. We'll be looking at the Civil Procedure Act. We'll also be looking at the Judicature Act. We'll also be looking at case law, among others. Okay, So basically, when we look at part A of the question, the issue there to formulate, okay? I know you have been taught from your LLB 1 that all issues must necessarily start with whether, whether, whether. But then there are also circumstances where actually an issue can start with what, okay? So that's what you should also pick today. So an issue may not necessarily be framed for purposes of answering civil procedure as whether, but you can also start by saying what, okay, in form of a question. So basically, from part A of that question, the issue that we pick, okay, that we are able to formulate is what is appropriate remedy, okay? What is the appropriate remedy? And that will be issue number 1. And of course, the appropriate remedy in the circumstances is an appeal. Appeal is the appropriate remedy. And also part A requires us to look at the initial steps to commence an appeal. And as you are aware from the facts show that this case was heard by the Chief Magistrate Court. So as such, we are looking at appeals from the Chief Magistrate Court to the High Court. So the initial step to commence such an appeal, okay, when you look at the law, and I invite you to look at Order 43 Rule 1, Sub-Rule 1 of the Civil Procedure Rules, that rule actually provides that a suit will be commenced by way of memorandum of appeal, okay, as the initial step to commence an appeal from the Chief Magistrate to the High Court. So the initial step, of course, would be to draft and you lodge a memorandum of appeal. But be that the case, it's also important to note that, however, in practice, whereas there may not be an express law that that provides that appeals from the Chief Magistrate Court to the High Court are by way of notice of appeal. But in practice, we always encourage that you also file, okay, or draft a notice of appeal, okay? So that's very important to note. So basically, with just that, you would have your 5 marks that are provided for under Part A of that question. Then let's proceed to Part B of the question. And Part B of the question, the issue that we would formulate from Part B is what are the principles governing appeals from the Chief Magistrate Court to the High Court. So when you're looking at this issue, it's prudent that you first define what an appeal is, okay? And of course, an appeal is a rehearing of a matter before a superior court, okay? Authority for that position, look at the case of FX Mobuke versus UEB, High Court Miscellaneous Appeal number 98 of 2005. It is authoritative on the definition. Then also you proceed to look at the principle that appeals are creatures of statute and that there is no inherent right of appeal. So there is no right of appeal that is inherent, that the moment you lose a case, then you are entitled. No, there is no inherent right of appeal, and authority for that position can be found in the case of Baku Rafael, Obdura, and another versus Attorney General, Supreme Court Civil Appeal number 1 of 2005. Then also important to note when we are looking at that issue is Section 220, subsection 1A of the Magistrate Courts Act. And basically that section provides that appeals from the Chief Magistrate Court lie directly to the High Court. So basically that would be it on that issue. Okay, of course, don't always forget to relate back to the facts. It's very important, and you make an analysis because most of the marks actually are on analysis and the application of the laws to the facts. That is extremely important. Please do not forget it. Let's proceed now, and we are still looking at Part B. Part B also requires you to look at the timelines, okay, at the timelines. So what issue would you formulate from there? What are the timelines for appeal from a Chief Magistrate Court to the High Court? And of course, authority on the timelines is under Section 79, subsection 1A of the Civil Procedure Act, Cap 71. And that section provides for 30 days, okay, within which you have to appeal from the Chief Magistrate Court to the High Court. So basically that's it. So in the instant facts, that means that Mr. Mitima Jakaluba has 30 days to appeal, okay, to the High Court. So let's proceed and we look at part C of the question. And basically from part C, the issue to formulate there is what are the elements to observe in formulating grounds of appeal. So when you're formulating grounds of appeal, what are some of the elements that you have to observe, to look at? What are some of those areas where you can actually pick these grounds of appeal? Okay, so we are briefly going to run through them. Element number one is procedural irregularities. So you look at any procedural irregularities that may have been committed. And if there are any, then those can form a ground of appeal. Number two, misdirection. So if a judge misdirected himself or herself to a certain legal principle or otherwise, then that can also become a ground or an area, okay, that formulates a ground of appeal. Number three are non-directions, okay? So a judge can misdirect himself, but a judge may also not direct himself to something which he ought or she ought to have directed himself or herself. Of course, that also becomes an element to observe when you're formulating grounds of appeal. Then also the failure to evaluate evidence. So the judge or court may fail to evaluate and make a proper analysis of evidence. If that happens, then that also becomes an element to observe in formulating grounds of appeal. Then also further, you can also look at the issues for trial before the lower court. What were the issues? You can also look at the decision made by the lower court on each of the issues raised, okay? Then you can also look at the evidence for submissions made by each party in support and in opposition of those issues. Then lastly, the pleadings filed by each party before the lower court. All those can always give you some of the elements to observe in formulating grounds of appeal. What is the principle to note? The principle is under Section 7 of the Civil Procedure Act, Cap 71. And the principle is a very simple one, that a good ground of appeal must point out a serious error or irregularity in the decision or orders of the lower court. So a good ground must point out those irregularities or any errors, okay, in the decision of the lower court, okay. Of course, that error or irregularity must be capable of affecting the merits of the case or jurisdiction and consequently causing a miscarriage of justice, okay. That is the principle to note. Then also from that part C of the question, it's also important to formulate another issue, which is what are the grounds of appeal from the facts of this case. So we are now proceeding to the grounds of appeal, having seen some of the elements that you can look at when you're formulating the grounds of appeal. So what are the grounds of appeal from the facts of this case? So there are three grounds from the facts of this case, as I briefed you on the same earlier at the beginning of this discussion. The first ground is disregard of key witnesses. As you saw in the facts, for example, Uncle bend down, okay, whose evidence was denied. So that is also a ground that you can rely on, okay. Then the second ground is misdirection on the admissibility of a Chibanja land purchase agreement of 1982. Okay, remember this was disregarded by the judge. Okay, and when you're looking at this ground of appeal, some of the areas of the law or the law to look at, okay, that is relevant is Section 8 of the Evidence Act, Cap 6. That section provides that facts necessary to explain a fact in issue are relevant. That when there is a fact, okay, which explains a certain fact in issue, that fact is relevant. In the instant case, when you look at that 1982, okay, Chibanja land purchase agreement, it is a fact that explains a relevant fact. Which relevant fact? As to the ownership of the land. And as such, it is relevant. I also invite you to look at Section 9 of the Evidence Act. That section allows courts to presume 30-year-old documents as genuine. You also look at there is an interesting case by Justice Stephen Mubiru, which is Adrabo Stanley versus Madira Jimmy, that is CS number 24 of 2013. In this case, Justice Stephen Mubiru held that a court may presume a 30-year-old document as genuine when produced in court as evidence. So Justice Stephen Mubiru was simply emphasizing the import of Section 90 of the Evidence Act, Cap 6. Okay? If you look at the instant facts, you'll quickly realize that there was that document, the agreement that was signed in 1982, is more than 30 years old. And the position of the law is that documents that are 30 years old and above, okay, can be presumed as genuine by court. So by court not going on to presume such a document as genuine and simply disregarded it in itself is a ground of appeal. Let's proceed and we'll look at the third ground. And the third ground is non-direction of the judge on competence and comparability of Prince Mananana as a witness. Okay, very, very important. So the principle basically governing competence and comparability of witnesses is that all competent witnesses are comparable to give evidence. That's the principle. The moment a witness is competent, then he can be compelled to give evidence. Okay? What is the law? Look at Section 117 of the Evidence Act. That section provides that all persons are competent to testify, except if suffering from disease, or they are of tender years, or they are of extreme age. Quite very clearly, you realize that our witness, okay, did not fall in any of those categories. He was not of tender years. At least the facts do not disclose so. They were not sick, okay? So as such, in conclusion, that witness, okay, was competent, and as such, court ought to have compelled him to testify. Okay, let's proceed and we'll look at Part D of the question. Part D, the issue to formulate there is as follows. What is the forum, procedure, and documents to be used in the premises? So let's start with the forum. So with the forum is the High Court. Appeals from the Chief Magistrate lie in the High Court. Authority, look at Article 139, Clause 1, okay, of the Constitution, and also I invite you to look at Section 220, subsection 1A of the Magistrate Courts Act. Let's now proceed and we'll look at the procedure. The procedure is as follows. 1, extract a decree endorsed and sealed by the court. Step number 2, draft a memorandum of appeal and file it in the High Court. Okay, you look at Order 43, Rule 1, Sub-Rule 1 of the Civil Procedure Rules. It is authoritative on the same. The third step, pay the requisite filing fees into the court. The fourth step, serve a copy of the memorandum of appeal on the respondent. The fifth step is file an affidavit of service. Then lastly, of course, hearing of the matter commences. That is the procedure. Let's proceed and look at the documents. The first document is a decree that you must have. The second document is a memorandum of appeal. And then the third document is an affidavit of service. Please, students, you must know how to draft these documents. Ensure that you're able to draft these documents. I cannot overemphasize the importance of this. Let's proceed and we'll look at Part E of the question. And the issue to formulate from Part E of the question is whether Mr. Mitima Jakaluba can rely on evidence of Uncle Ben Down and the sales agreement. Okay, that is the issue. And yes, he can. Okay, the quick answer is that yes, he can rely on it. What is the law? Look at Section 80, subsection 1D of the Civil Procedure Act. That section allows court to take additional evidence. Furthermore, also interest yourself in Order 43, Rule 22. That order allows the High Court to take evidence of the lower court, or to take evidence which the lower court had refused. Those are the two authorities that you can use. Let me also give you an interesting case which can also follow up those two authorities. That is the case of Daharansi, Maraj and Sons Limited versus S.N. Kara. It's a Supreme Court Civil Appeal number 27 of 1996. In that case, court held that exceptional grounds must be proved to allow additional evidence. These grounds include the following. Ground number one, the party intending to rely on additional evidence must not have adduced it, or that party could not rather have adduced that evidence at the first instance. Okay, that is the first ground. The second ground is that the party affected by such additional evidence must have an opportunity to rebut it. And then lastly, additional evidence must be relevant to determine the issue at hand. Quite obviously, you realize that all these three grounds are applicable in the instant facts. At first, you can see from the facts that Mr. Mitima Jakaluba could not have adduced that evidence, or even if he did, the judge actually set it aside and he did not consider the evidence. But also secondly, in the appeal, okay, the respondent would have a chance to rebut such evidence if adduced. And then also lastly, when you look at the nature of that evidence, it is relevant. Remember earlier I directed you to look at Section 8 of the Evidence Act, which provides that all facts that are relevant, okay, are admissible, okay, provided they are proving a certain issue that is under contention. So meaning that this evidence that pertains to a 1982 agreement is relevant to prove an aspect pertaining to who owns the land. Because remember, there cannot be trespass if a person cannot trespass on their own land. So meaning that if this agreement is adduced and it shows that Mr. Mitima Jakaluba is the owner of that land, that means that the suit, okay, on trespass would collapse. Let's proceed and we'll look at part F of the question, which is the last part. So the issue that can be formulated from part F is what steps can be taken to prevent the eviction. Basically, these are the remedies. Okay, so the first step, or one of the first steps that can be taken in the premises to prevent the eviction, because remember Mr. Mitima Jakaluba, remember court passed an order to evict him, okay, and he would also of course want to take steps to ensure that he's not evicted. So what steps would he take? The first step, apply for stay of execution pending appeal. Authority, Order 43, Rule 4, Sub-Rule 1 of the Civil Procedure Rules. When you look at that provision, it provides that pendence of an appeal is not a bar of execution, except where the High Court so orders. Okay, so basically that is it. The second step that can also be taken by Mr. Mitima Jakaluba is an interim stay of execution pending the determination of the main application for stay. Okay, those are basically the two steps that can be taken. Let's now look at, still under part F, let's look at what must be proved to be granted the above remedies. We have seen those two remedies, which is stay of execution and an interim stay of execution pending the determination of the main application for stay. So here we are now going to look at what grounds must be proved so that those remedies are granted. So we are going to first look at the first grounds on stay of execution pending appeal. What is the law? I invite you to look at Order 43, Rule 4, Sub-Rule 3, A2C of the Civil Procedure Rules. It provides for those grounds. And I also invite you, in the same spirit, to look at the case of Lawrence Musitwa Chaze versus Eunice Businje. It's a Supreme Court Civil Appeal, okay, or number 18 of 1990. So both those two authorities, that is Order 43, Rule 4, Sub-Rule 3, and that Supreme Court decision I've shared with you, both of them provide for the grounds, but briefly, which are as follows. Ground number one, substantial loss may result to the applicant if the order is not made. So that's one of the grounds that you have to prove for you to succeed under this remedy. Then the second ground is that an application has been made without unreasonable delay. You have to show that your application has not been delayed. Then thirdly, that security has been given for the performance of the decree. You also have to show that you've given some sort of security. Okay, let's now proceed and we look at the second step or the second remedy, which we said is interim stay of execution pending the main application for stay. Okay, this is also a remedy. What are the grounds? I invite you to first look at the authority of One Sang Industries Limited versus Tajdeen Hussein and two others. It's a Supreme Court Civil Appeal number 19 of 2008. When you look at that decision, court held that the grounds for grant of an interim order for stay of execution are as follows. Ground number one, whether there is a substantial application pending. Is there a substantial application? There must be a substantial application because this application is made, okay, so that a miscarriage of justice does not happen. You already put in an application for stay of execution, but the defendant is proceeding on rocket speed to go and take action. And you're only praying to court that your lordship, this person should be stopped immediately. That whereas I put in an application for stay of execution, but this man is moving very fast, okay, to take over my property. Therefore, you should give me an interim stay of execution pending the hearing, okay, of the main application for stay. So it is therefore very important as a ground to show whether that there is a substantive application that is pending, okay, as a first ground. Then the second ground is whether there is a serious and imminent threat of execution before hearing the substantive application, okay? And of course, it goes without saying that a notice of appeal must be on the court record. So this second ground here, whether there is a serious and imminent threat of execution, there must be a serious and imminent threat. Someone is executing in the next 1 hour. Someone is executing in the next few minutes. There is an imminent threat and court has to step in and curtail a possible injustice that may emanate from the same. So, ladies and gentlemen, that was the approach to question number 1 of that past paper. And that is what any student would be expected to look at. Of course, again, I emphasize, do not forget to relate the law back to the facts, because that is where the majority of the answers, the majority of the marks fall. So you must always relate, okay, your authorities, you must always relate your legal principles and marry them with the facts in the problem question, as I've clearly illustrated for you. Thank you very much, ladies and gentlemen. Once again, my name is Mutiaba Conrad, and please do not forget to subscribe to my channel so that you're able to always continuously get these updates on question approach. I will also be releasing more question approaches in some of these past papers. Thank you very much. God bless you. Bye-bye.